So I'm going to talk to you about the types of things that we do for people who get a foreclosure notice. And I got 5 steps here that I'm going to go through. And the first 2 of them, you don't need to be a bankruptcy attorney to know about or to help people with. So the first thing is the foreclosure extension process under Minnesota Statute Section 580.07. That was a law that the legislature put through about 5 years ago, quite typically for people who were hearing it from both ends. They were working on a loan modification, supposedly with their mortgage company, and then lo and behold got served notice of a sheriff's sale and couldn't get a hold of anybody anymore. So what the legislature did is they gave people the option, and it's a once-in-a-lifetime option in the course of your mortgage, you can't do it successively, to push the 6-month redemption period, or to shorten the 6-month redemption period by moving the sheriff's sale date back 5 months, and then it shortens the redemption to 5 weeks. So if all someone does is the extension and doesn't do anything else, it doesn't change their ultimate move-out date. But it gives them more time to do a loan modification, which a loan modification can be done after a sheriff's sale, but you don't have any more leverage, because if you're going to file a bankruptcy, you usually want to do that before the sheriff's sale. So we do a lot of those when people come in. So there's a few things that you need to know about that. Is that the redemption gets shortened. Some people don't understand that. They think they get 5 months and then they get a whole new 6 months redemption period after that. The statute refers to, it says the mortgagor is assigned. So if you have a husband and wife, the judges and the attorneys have been saying that both spouses must sign that. If it is a divorce situation where the house has been quitclaimed and you can demonstrate that to the foreclosing attorneys, I've had some of those go through. The property needs to be homesteaded, so that's something that you always want to check. You can easily verify that online. If it's not homesteaded, it's a simple deal. You have the client fill out the form and take it down to their city hall, and then you can do the foreclosure extension. It needs to be done 15 days in advance. So basically, you fill out the form, very simple. It's a 1-page form. You put in their legal description. You say, I wish to extend this. You attach the sheriff's sale notice. You take it down to the recorder's office, it's $52. You serve a copy on the sheriff, and then you serve a copy on the foreclosing attorneys, and fax will work. And then you verify that they'll accept it, because they will still verify that the sheriff got it, it's filed on time, and that all mortgagors have signed, and that they're all good. And then they'll confirm the date, which will be 6 months out. If that's on a weekend, it'll be the following Monday. And then, like I said, you only get one of those. So what I'll always do, and we've done these a lot of times, is we'll file for this, and then the mortgage company will say, no, we already canceled your sheriff's sale. So then it's kind of a waste of time. So we always make sure that hasn't been done. And then plus, if they've already canceled it themselves, then you still have that one right to do that in the future in your pocket. So the best way to save a house is through loan modification, and there's some great programs out there, and there's the HAMP programs and the HART programs, and that's been the subject of a whole separate CLE. I'm not an expert on all that, but a few things to know is Fannie Mae and Freddie Mac, which own 40% of the mortgages in the country, do participate in that. So the big question is, will your mortgage company participate in it or not? And there's, it's public information, although you need to know the last 4 of your social. I guess, that used to be anyone could go look it up, and you could go up and down your street and see whose mortgage is owned by Fannie Mae and Freddie Mac. Now they have, you got to have the last 4 of your social, and you have to click that you're either the homeowner or you have their consent. And then if you see that it's Fannie Mae or Freddie Mac, you know that they have an entitlement to a loan modification under the HAMP program. And these loan modifications are awesome, because what they'll do is they'll take the arrearages, they'll spread it out, re-amortize the mortgage. They can do it up to 40 years. They can take the interest rate down to 2.5% or 3%, and that ends up lowering people's payments. And then sometimes they'll even reduce some of the principal, although I haven't seen too many when they do that. So if you're you look it up and you're not Fannie Mae or Freddie Mac, that doesn't mean that you're not going to get a loan modification, but your chances of getting one are going to start going down because it's a lot of red tape, and I don't get involved in loan modifications. I tell people you should be, if you were smart enough to get a mortgage in the first place, you should be smart enough to get it modified. And mortgage companies have procedures and processes and departments. They've gotten better about it. And the Attorney General has done a warning that says you should not pay anybody, because that was the big cottage industry 5 years ago when all of the real estate people and appraisers and refi mortgage people were having trouble making ends meet. They said, hey, we'll get into the loan modification business, and they would collect money and basically a lot of rip-offs going on, a lot of out-of-state companies that were coming in and they weren't being properly regulated. So they have rules, they made a new statute. You're not supposed to collect money up front for a loan modification. You can only collect money once it's been successfully done, except an attorney can legally collect money up front for a loan modification. I just have never found it to be cost effective, because all you're doing is you're just adding another layer of communication, and things need to go back and forth. But the clients need to know that it can be a cumbersome, frustrating procedure, and they just need to stay diligent on it because they don't hand these out. Yes?
How many payments are these clients missing before they're modifying their loan, if any?
Well, typically about 3 to 6 is what I see. When you get 3 to 6 months payments behind, that's when the mortgage company will usually start taking it from their in-house loss mitigation department and sending it off to an attorney. The attorney will then send, it'll be a local foreclosing attorney, they send a 30-day debt validation notice, and then they'll serve a notice to the sheriff's sale. So that's kind of the normal time parameter. Sometimes I've seen people go 9 to 12 months. Sometimes if people are actively working on the loan modification, they can stretch that process out a lot. So typically what happens is when they do actually get a hold of the right person in the loan modification department, there is a 3-month trial modification period, and I'm not entirely certain why they do it that way, but I think it's because a lot of people don't make the first 3 payments, and they said, well, let's sort through before we put all the time and energy into this, the people who can make 3 payments and are going to be diligent, and the people who are just yanking our chain. So you do the 3 months, and then sometimes people don't hear from their mortgage company for 6 months, and then they go into foreclosure. But usually if they've started on a loan modification, they can, and got it dropped, they can get it jump started. And one thing about it is I help people not pay their debts. I guess you could say that I help people be irresponsible, but I think it's out of necessity. But one thing I don't like about these statutes is that people can get unlimited numbers of loan modifications. And sometimes people do end up getting this entitlement mentality that, hey, all I got to do is stop making my payments for a few months, and then I make a call, and then they spread it out. And I've seen people do that 3 or 4 times. I think that at a certain point there should be some responsibility on that, but right now those are the rules, and people can usually get a loan modification even if they can't afford the payment as it should be amortized with. If it's going to be more than 30% of their gross income, they can actually have a payment that's negatively amortizing and just at 30% of their income. So there's some great programs out there, and that's usually the best way to save their house. Now, if someone cannot get a loan modification and they want to save their house, then we can file a Chapter 13, and basically what we do is we take the arrearages, we call them the pre-petition arrearages, we find out what that is, and then we put that into a Chapter 13 plan, and we spread it out over 3 to 5 years. That needs to be filed prior to a sheriff's sale. It will stop the sheriff's sale. If you file it after a sheriff's sale, you're not accomplishing much unless you pay the whole mortgage off within the 6 months, because there's not much of a right to do that. The one thing is people do need to be able to afford their payments. So sometimes we'll get people who have a you know, a $1,900 mortgage payment, and I've had people that have fallen through the cracks and haven't made mortgage payments for 2 or 3 or 4 years before they finally go into foreclosure, and sometimes they're $60,000 in arrears.